Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is called My Buyer Terminated the Contract and the Seller Won't Sign the TNR. What do I do now? And it could be a seller that terminates a contract, but usually the majority of terminations that we see are initiated by a buyer. So you're an agent, you're working with a buyer terminates the contract, you write up the TNR, and in the GAR contract package, the termination and release agreement is on one form, and in the RE forms contract package, the termination is on one form, and the agreement to release the earnest money is on a separate form. So these are two completely separate contractual issues: terminating a contract and agreeing to release the earnest money. I've done several videos on this topic. I just wanted to actually talk about, as an agent, what do you do when the other party won't sign the TNR, and give you a few examples that dispersing the earnest money, figuring out what happened contractually, isn't quite as easy as you may think. So again, these are two completely separate contractual issues. Terminating a contract, that can be done by notice, and notice is unilateral. So either a buyer or a seller may terminate a contract. You do not need the other party's signature to terminate a contract, and once it's dead, it is dead. And terminated contract may not be revived by amendment. However, the agreement to disperse the earnest money does require both buyer and seller signatures. So you don't need the seller signature. You don't need both party signatures on the termination. You do, however, need both signatures on the agreement to release the earnest money. That is spelled out in the contracts, and that is license law. Again, I'm not going over specifically where these are in the contracts. I have done this in several videos. I just wanted to tell you guys procedurally what to do and then give you some examples. But if this procedures, this is spelled out in both the GAR and the RE contract forms in the section under earnest money, in the notices section, and for the issues I'm going to talk about under terminating under financing, those are spelled out under the financing exhibits. So what happens is, let's say you're representing a buyer terminates the contract, you fill out the TNR, as we call it, buyer signs the notice to terminate. Generally speaking, what we see is the buyer wants the earnest money coming back to the buyer. Buyer signs the agreement to release the earnest money. You send it to the seller, and before the holder can release the earnest money, the holder needs the seller's signature on the agreement to release the earnest money. If you don't get that, what do? Well, first thing you need to do is have a conversation with the listing agent. And again, as I mentioned, either party can terminate, but generally speaking, we see a buyer terminating, needing the seller's signature. So you contact the listing agent and have a conversation to find out what's going on. Why aren't you getting the seller's signature? Once you realize you're not going to get the seller's signature, then what you need to do is you need to turn in the TNR, because you have to turn it in. It's already terminated. The only thing in dispute right now is the disbursement of the earnest money, but it is a terminated contract, and the parties now have no further obligation to with respect to the contract. Now, there are some other potential legal issues, but generally speaking, so you turn that signed TNR into your broker, because your broker is going to need it for their files, and you are going to have to contact the holder of the earnest money. Now, that may be your broker, that may be the other broker, or that could be a closing attorney. But now it is your responsibility to notify the holder of the earnest money that there is a dispute regarding the disbursement of those funds, and now the ball is in the holder's court. So again, I've talked about this, and this is all spelled out in the earnest money section of both the GAR contract and the RE forms contract, that the holder of the earnest money has several options, if the agreement to disperse is not agreed upon, it is in dispute. One of the things the holder can do is interplead those funds into a court, let a judge decide, and the holder gets to take those court costs and legal fees out of the earnest money. And generally speaking, the loser has to pay the winner's legal fees if the winner has an attorney. The other thing that the holder can do is write what we call the 10-day letter. The holder goes through the contract, makes an interpretation, figures out why did it terminate, why didn't it close, the party that terminated, did they terminate under a contingency that had not yet expired, or did they terminate by default? The holder goes through the contract, gets all the parties' names, contact information, contacts the agents to find out what happened, make sure that the holder has copies of all of the documents, all of the amendments, all of the exhibits, makes the interpretation, sends out a notice to all the parties saying this is my intent to disperse the earnest money. Then we have to wait 10 days to get an objection from the party not getting the earnest money, why are objecting to our decision. If that objection is contractually based and the holder changes their mind, a new 10-day letter is sent out. If that objection is just the party being upset, not agreeing, but not contractually based, the original time frame stays intact, and then the holder can disperse those funds to whom they said they were going to on at least day 11 or later. And again, the actual disbursement depends on if it's a business day or a weekend or a holiday. So that's kind of what happens. Now, I will let you know if it is an all-cash transaction and the closing attorney is the holder of the earnest money, the closing attorney does not have the option to interpret the contract. The closing attorney must interplead those funds into a court, and it gets expensive. So just take a look at that. So so that's what you do as an agent. You have to notify not only your broker, but you have to notify the holder. And when you're notifying the holder, you would probably want to state your case regarding the earnest money and why your client should get it based on whatever happened and why it terminated. So now what does the holder do? Well, in terms of interpreting the contract, there are some basic things that we do as holder. The first thing that we do is we take off our client hat because if we're the broker and we represented either the buyer or the seller, obviously if we were in a client relationship, we would represent that party. However, now that we have to make a decision, interpret the contract, and release the funds based on that, we take off our client hat and put on our neutral holder hat, because we have been entrusted with these funds as a neutral third party to interpret the contract regardless of which party was our client or not. And there is license law that holds brokers accountable for their decisions. We can be held, not individually as well as the whole firm, can be deemed incompetent to disperse the earnest money contrary to what the contract says, just in favor of your client because it's your client. So as the holder, first thing we do is we go through the contract and we look at the dates. First thing we look at is binding agreement date. Then we go through the contract and we look at all the contingencies. What contingencies did the buyer and the seller agree to? What were the time frames for those contingencies? Were any of those contingencies amended? And we look at the amendments for that. Then what we do is then we have to look at the actual termination notice that was sent, the party that terminated. What date was that termination notice signed, and what date was that termination notice sent to the other party? So the dates are very important, not only of when it was terminated, but more important is when that notice was sent to the other party. Then in terms of notice, and again, you guys, this is all spelled out in the purchase and sale agreement. I've done several videos on all these issues. Then not only when was that termination notice sent to the other party, but by what means and to what email address. If it was sent by email, the email that the let's just say it's the buyer that terminated. The buyer's agent when you terminated on behalf of your buyer, when the buyer terminated and you as the buyer's agent, you sent that notice of termination to the listing agent, what email address for the listing agent did you send it to? Did you send it to the email address that was printed on the purchase and sale agreement? That is required per the contract. So we look at the dates that it was sent, and the email addresses, as well as the contingencies and contingency timeframes. So that's the basis of what we look at to figure out the party that terminated. Did they terminate by an unexpired contingency, or did they terminate by default, to figure out who gets the earnest money? If it was terminated under a contingency that hadn't yet expired, then the buyer would get the earnest money back. If the termination was terminated outside of the contingency time frame, or for a reason that was not agreed upon between the buyer and the seller, then the buyer defaulted, and the earnest money gets dispersed to the seller as liquidated damages. And this is all spelled out in the default section of the purchase and sale agreements, both GAR and the RE forms. If you have ever been in any of my contracts classes, you will repeatedly hear me say that the contracts are nothing more than a set of instructions. So everything is spelled out in the contract, the procedures, and what has to happen. So let's get into a few examples. So let's say that the buyer and seller agreed on a 10-day due diligence period, and the buyer terminated on day 5 from the binding agreement date, sent the notice of termination to the seller on day 5 or day 6 from the binding agreement date, and for whatever reason the seller does not sign it. Well, that one is pretty clear. Well, maybe. First of all, we get in touch with the agent, the buyer's agent, and say, show me, I've got a copy of the TNR, so I see the date that the buyer actually terminated. Now, from you, the agent, I need a copy of the email where you sent that buyer's termination to the listing agent. I need to make sure that that was sent before the end of the 10 days. And I need to make sure that was sent to the email address of the listing agent, who is the client of the seller, as written on the signature page. So if in fact, let's say they agreed upon a 10-day due diligence time frame, buyer terminated on day 5, sent it on day 5 or even day 6, for whatever reason the seller won't sign it, pretty cut and dry. That one's pretty easy. Buyer's going to get the earnest money. Nevertheless, I still have to write the notice of who I'm going to, which party I'm going to disperse the funds to, and why, and I just spell all that out. Still have to wait 10 days from the date of the notice, cannot disperse until day 11, and then after I disperse the funds, I send another notice to the party saying I have dispersed the funds per the notice previously sent. If buyer terminates on day, let's say the TNR was dated on day 10 of a 10-day due diligence period, but the buyer's agent didn't send it until the next day, guess what? Buyer is now in default, because the notice section of the purchase and sale agreement says not only does the buyer have to meet that contingency prior to that time frame, but notice of that action has to be done before the end of that time frame. All right, another example. Ready? Financing. Also, let me go back to due diligence. If a buyer is terminating before the expiration of the due diligence period, on the TNR, you just mark that they're terminating based on due diligence. You do not need an explanation. When a buyer and seller agree to a due diligence period, the seller is giving the buyer the option to terminate prior to the expiration of that time frame for any or no reason. Don't put in a reason, just put they're terminating under due diligence. Okay, financing. Let's say a buyer gets denied for their loan. Let's say they agreed to a 21-day financing contingency. They send the termination to the seller on day 18. But they don't send the loan denial letter, and the seller doesn't sign it. Well, if you are binding under the GAR contract, if a buyer terminates under the financing contingency, well, in both GAR or the RE forms, if a buyer is going to terminate under a financing contingency, you must not only send the termination prior to the end of the time frame, but you must send the loan denial letter. So if you're binding under the GAR contract, once you send that termination notice, you have 7 days to send the loan denial letter. If you're binding under the RE forms contract, you must send that loan denial letter simultaneously with the termination notice. So if you're binding under GAR contract, buyers, and you're terminating under financing and the seller doesn't sign it, a lot of listing agents, and if I'm representing a seller, I would probably encourage my seller, it depends on the situation, to not sign the TNR until I get that loan denial letter. That could be 7 days. And as I've mentioned in the previous video, that earnest money is tied up until it is released. Buyer can't use it for another property. So if a buyer is going to terminate under a financing contingency, you want to make sure to get that loan denial letter. Send all of that based on within the loan denial letter must be sent within the time frame as outlined in the contract. Again, GAR, 7 days after the notice of termination, and RE form, the loan denial letter must be sent simultaneously with the notice to terminate. Now, let's say again, buyer is terminating under a financing contingency. So in the loan contingency exhibit, you fill out all that information, the percent of loan that the buyer is getting, the interest rate, the number of years, if it's fixed or adjustable, so forth and so on. Now, let's say the buyer terminates under financing contingency because their loan gets denied. You send the loan denial letter, but the seller doesn't sign it, comes to the holder. Well, guess what we look at? We look at that loan denial letter. That loan denial letter, the loan that's denied in that letter must be for the loan that was described in that loan contingency exhibit. So let's say that you fill out all that information on a loan contingency exhibit, but the buyer and the lender end up to pursue a different loan. The loan that they ended up pursuing is what gets denied. So you terminate under financing, you get the loan denial letter, but the loan described in the denial letter doesn't match the loan in the exhibit that the buyer and the seller agreed to. What happens? Buyer get the earnest money or seller? Guess what? Seller's going to get it because the buyer defaulted, because it clearly states in the loan exhibits that the loan that must be denied must be the loan as described on that exhibit. Now, let's give another example. Now, let's say there was a buyer, financing contingency, and the financing contingency, the loan gets denied. Let's see. The buyer was going to down payment assistance funds from whatever program, Georgia Dream or a number of the down payment assistance programs out there. They get denied for their down payment assistance program, so their loan also gets denied because the buyer doesn't have the cash in order to bring on their own in order to get the loan to close the loan. So buyer terminates prior to the end of the financing contingency exhibit. They send the loan denial letter, but the loan denial letter states that the reason the loan is being denied is because the buyer doesn't have the cash for their down payment to bring. And you say, yeah, but they were getting down payment assistance funds, but that wasn't in the contract. What happens? Who gets the earnest money? Buyer or seller? Did the buyer terminate under what is that part of the financing contingency, or did the buyer default? Answer is buyer defaults. It clearly states, again, in the loan contingency exhibits in GAR and in the standard terms in the RE forms, that loan denial letter, there are certain things that cannot be on that loan denial letter. In other words, the lender has to deny the loan based on standard underwriting criteria, but it specifically states that if the loan is denied for certain things, the buyer does not meet the terms of the financing contingency. And one of those things is the buyer having enough of their own cash to close and cover the closing costs. So if a buyer is getting down payment assistance funds from one of the grant programs out there and they don't get that, if you did not make the contract contingent upon the buyer's successful receipt of those down payment assistance funds, they're not protected in the financing contingency. That is not a reason for the loan denial letter. Problem is, they're not going to get their loan, but they are also going to lose their earnest money. That is not a protection in the financing contingency if you did not make that a special stipulation. Maximum 1 agents, we have this verbiage in the special stipulations to consider that is available to you in the reference section of Paperless Pipeline. And if you've taken my contracts classes, I have shared these special stipulations with you as well. All right, here's another one. We're going to get a little more complicated. Let's say a buyer terminates under the financing contingency and the loan denial letter states that the buyer had a bankruptcy and therefore doesn't meet the underwriting criteria and can't get the loan. Right then and there, we're good. However, so the buyer sends that to the seller. Seller's getting ready to sign the agreement to release the earnest money back to the buyer. Then, however, a few hours later, the buyer's agent sends the listing agent another loan denial letter that says, no, the bankruptcy issue wasn't an issue. It's the fact that their credit didn't meet the terms that they need. Then you get another loan denial letter from the lender that says, disregard those other 2 loan denial letters. Here's the reason. The reason is, the first one was because they didn't have the cash. Then the second one was a bankruptcy. And then the third one was that they didn't have the credit. So at this point, the listing agent and the seller are like, what is going on here? They're like, we're not going to sign this because we don't know why the buyer's loan is getting denied. What is going on? Is it that they don't have the cash to close, in which case they're in default? Is it that they have a bankruptcy that the lender didn't see for whatever reason? Is it that their credit, so forth and so on? So they don't sign it. They send it to the holder. So as the holder should contact that lender and say, what is going on? We've gotten some varying reasons for the loan denial letter. We're not sure what's going on. So on a Friday, get an email back from the branch manager of the lender that says, I apologize. This is an in-house issue. The loan was not denied. This is being taken care of in-house. Email back to that lender branch manager saying, fine, no problem, but we need that in writing on your letterhead. Then on Monday, get another email from the manager of that lender saying, nope, go with the second loan denial letter. That was the real reason the buyer's loan is denied. Please proceed with the disbursement of the earnest money back to the buyer. Well, at this point, as the holder, there is too much, there is a bona fide dispute or reason to believe that there is something going on above and beyond the holder's determination, above and beyond the contract. So what would you do? Well, the holder ended up interpleading the funds into the registry of a court. The earnest money was only, well, I don't remember. It doesn't matter. Anyway, went to a court. The attorney, you have to hire an attorney to file a motion to interplead the funds. The attorney then has to send notice to the parties regarding this lawsuit over the earnest money. If the attorney can't send notice to one of the parties, then you have to keep sending notice, and those attorney's fees rack up, and the holder gets to take those fees from the earnest money. So this ended up being interpled, went to court. Neither party showed up to court. So the case was dismissed, but at this point, the legal fees and court costs exceeded the amount of the earnest money anyway. So the holder ended up, from the earnest money, paying, or the court ended up paying the attorney's fees from that earnest money. So that was an interesting one. All right, here is another example. Let's say you have a buyer and a seller. You have a closing date. The closing date comes and goes. Neither party, or you just don't close. Then, well, you still have to disperse the earnest money. The holder can't keep the earnest money on a contract that failed to close. So at that point, we get or the holder gets a TNR from the seller saying, the contract failed to close as of the last agreed upon closing date. The seller is to get the earnest money as liquidated damages because the buyer failed to show up to closing. Goes to the buyer's agent. The buyer doesn't sign it saying, no, we didn't close because our loan was denied and we have the loan denial letter. So we're not going to sign it. We weren't able to close. Well, guess what? Who's going to get the earnest money? Seller's going to get it. So even if a buyer doesn't meet a contingency, you can't just not close. You have to send that notice of termination prior to the end of a contingency and definitely prior to the end of a closing date. If it just doesn't close, there's one party that didn't close for whatever reason. Okay, here is another one. Let's say there is a buyer and a seller getting ready to close, and there is it just doesn't close, fails to go to closing, and neither party closes. And there's a TNR sent by the buyer to the seller saying the buyer wants the earnest money back. Seller won't sign it. Holder has to go through the contract and figure out what happened. Well, throughout the course of this investigation, come to find out that the buyer and the seller went under contract with a conventional loan contingency in the GAR contracts. Then the buyer switched to an FHA loan. The buyer sent an amendment in the GAR contracts. If a buyer is switching loans from a conventional to FHA or VA, the buyer must get the seller's written approval. The buyer can't just switch loans on the seller without getting the approval of the seller. Buyer sent the amendment to the seller. We're switching to an FHA loan. Seller never signed the amendment. So the buyer never got their loan, but the loan that they didn't get was the FHA loan that the seller never agreed to. However, also come to find out that there were title issues on behalf of the seller. Now, we have to do a little more digging. The holder has to do a little more research. Well, how did you find out there were title issues? Was it just an email from the closing attorney to the parties? That doesn't count. You guys, you've got to read your contract. In the paragraph about examination of title, it specifically says that if there is that the buyer has the right to examine the title, and if there are any issues, the buyer must send the seller notice of a title issue if the seller can't convey good and marketable unencumbered title prior to closing. And then the seller has so much time frame to cure, and then the buyer can terminate. Well, so we, throughout the course of the investigation, holder found out, yes, the buyer, in fact, did send that notice to the seller of the title issue. There was a cloud on title that the seller did not clear up by closing. So in this instance, there was, in essence, a mutual default. The buyer did not get the loan. Well, they were coming to closing with a loan that the seller did not agree to and didn't close, and the seller had a title issue, and they were properly notified per the contract of that title issue. So in the case of a mutual default, there is to be no penalty to either party. So in that case, the buyer gets their earnest money back, so they're not penalized, and the seller has the house still to sell. So in a mutual default, there's not going to be any penalty, meaning the buyer's not going to be penalized by losing their earnest money. All right. Here is another one. Let's say that a buyer and seller go binding with a sale or lease contingency exhibit, and on that sale or lease contingency exhibit, that contingency time frame coincides with the closing of this new home. If you read through that sale or lease contingency exhibit, it clearly says that if a buyer does not meet the terms of this contingency, in other words, doesn't sell their house, the contract automatically terminates. So it was automatically terminated, but afterwards there still had to be the agreement to release the earnest money signed by the buyer and the seller. So you would still have to do a TNR with the earnest money in that situation would go back to the buyer because the buyer did not meet the terms of that sale or lease contingency within that time frame, which was selling their house before that time frame that happened to coincide with the closing date. All right, and let's do one more. Let's say that a buyer and a seller go under contract with a due diligence period. Throughout the due diligence period, the buyer has some independent inspections done. Buyer and seller agree on an amendment to address concerns with the property. Seller agrees to do certain repairs to the property, getting ready to do a walkthrough the morning of closing. It turns out the seller has not completed all the repairs or has not given receipts when they said they were going to give receipts. The buyer terminates the contract. Does the buyer get the earnest money back? Did the buyer, in the TNR, it said other lawful reason, seller did not perform repairs as agreed to in amendment to address concerns. What happens? Who gets the earnest money? Guess what? In this situation, this more than likely would be interpleaded into a court, because repairs in and of themselves, when a buyer and a seller are negotiating for repairs in and of themselves, if you don't address termination rights for a seller's lack of performance, there's not an automatic termination. Well, there's two legal arguments on this, and I've done several videos on this. But in essence, one valid legal argument is that there were no termination rights expressly agreed upon should the seller not perform those repairs. So the buyer doesn't have termination rights, where termination rights are specifically spelled out with termination rights, notice of default, time frame to cure, time frame to terminate. All of that is spelled out very clearly in the contracts if there are termination rights. So if there's no specific termination rights spelled out, buyer doesn't have that right to terminate. The other valid legal argument is the seller agreed to do those repairs. If the seller didn't do them, the buyer should not be obligated to purchase that home when the seller is not agreeing to part of the contract that they said. Guess what? That is going to be up to a judge to decide. And again, I've done other videos on this extremely complicated topic. So, couple things. One is whenever you are working with a buyer and a seller agreed for the seller to perform certain repairs prior to closing, you have got to address the outcomes or consequences should the seller not perform those repairs. Are there going to be termination rights for the buyer? Is there going to be compensation held in escrow? Is there going to be compensation that a seller has to pay a vendor? All of those things must be addressed, not when it's an issue, but at the time you are negotiating for those repairs. Again, Maximum One agents, these special stipulations are spelled out for you, written by attorneys, and there are a lot of these special stips in the GAR and the RE Form Special Stips Library. But for you Maximum One agents, they are under those special stipulations to consider in the reference section of Paperless Pipeline. Please, please, please include special stips whenever you are negotiating for repairs. The other general thing I want to talk about is if a holder is going to interplead the funds into a court, the first thing that the holder should do is notify the parties that this decision either involves too much money, is too legally complicated, or just has too many factors, and it's going to be up to a judge to decide before I interplead those funds into a court, because it is costly and it does subtract the funds from the earnest money. We are once again going to give the buyer and the seller the option to negotiate the disbursement of the earnest money prior to it going into an interpleader action with the courts. If you are agents working with the buyer and the seller, please, please, please take some time and go through with your clients to negotiate the disbursement of the earnest money if in fact you do find out it is going to a court. The other thing in general I want to say is in the disbursement of the earnest money, it is always up to a buyer and a seller to negotiate what happens with those funds. A buyer can give the seller the earnest money 100%. Seller can let the buyer have the earnest money 100%. Or they can choose to negotiate it, split it up however they want. So that is always open. And even if a buyer clearly defaults on a contract, the seller can give the buyer the earnest money back. Oh, that reminds me, one of the things I said about if you're a seller and you get a termination under financing from a buyer, but they haven't yet sent the 7-day loan denial letter, you could wait the 7 days. Or if you already have another backup contract, you can go ahead and disperse the earnest money back to the buyer and move on with another contract or whatever. Again, it doesn't matter if a buyer and a seller agree on the disbursement of the earnest money in total or in any kind of negotiated way. All they have to do is sign that and get it to the holder so the holder can disperse those funds. Ooh, this was a long one. Thank you guys so much for watching. Just wanted to go through that a little bit with you. If you have any questions, please contact your broker. Especially, you need to contact the holder of the earnest money. And again, a termination does not need to be signed mutually, but the agreement for the disbursement of the earnest money does need to be signed mutually. You need to let the holder know, and you need to definitely let your own broker know that we have a terminated contract. But I hope that some of these examples helped you guys out a little bit, as well as talking through the procedures. Please read through your contracts, and hope this contract tip helped you out. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.